Good morning. Can everybody hear me? Yep. Can people hear me?
I can hear you.
Perfect. Well, I will work on the basis that everybody else can hear me. If there's any problem, please just send an email around on the sort of the Q&A section. Perfect. Yep. Somebody else has confirmed they can hear me. So great. So Johnny and I are going to tell you a little bit about construction and arbitration. I will deal with the construction side, and I think Johnny will deal with arbitration and the international aspects of that. So I suspect the starting point is what is construction law, because it's not a topic, or certainly wasn't a topic when I was at university that people would see. So what is this? So construction, it isn't a legal term of art or a technical term. It's construction law encompasses many different areas, but generally disputes regarding the built environment, so disputes regarding property, residential, commercial, power stations, roads, infrastructure project. It's got a huge, it's a huge area. And there's not only the contentious side, but there's also what we call the non-contentious side. So that's the actual putting together of the contracts, it's procuring the project, it's working out financing for the project. So generally, construction can be split into those two different areas, between the bits where it goes wrong, where you end up in court or some other dispute resolution procedure, or the other bit, the front-facing side, where you're dealing with clients who want to procure a project. So you might be giving advice on the appropriate way to go about procuring a project. So that's putting in place the funding to do that, purchasing the land, getting together what we call the professional team. So that's people like the architect who will design the superstructure of the building. It will be the engineers who will advise on the groundworks and the structure of the building, which keeps it upright and safe. So that there's that element there with putting together that team, the basis on which those individuals or entities are retained. And a lot of that involves dealing with who is going to share in the risks of the project. So it's a very different area to the contentious side, which is where it starts to go wrong. So in terms of somebody who wants to deal with construction work, it's attractive in the sense that you can deal with the two aspects. You've got the drafting side, the dealing more with the clients, how you put that project into place, the funding, as I've said, the insurance arrangements which go with it, and then you've got the contentious side, the side which I deal with, where something sadly has gone wrong. So you're dealing with that aspect. In terms of the subjects which construction draws on, in terms of the academic subjects, it's essentially dealing with contract and tort. So my working day is dealt with, and I suspect Johnny's isn't dissimilar, is looking through various contracts, working out what the obligations on the parties were, whether the parties have complied with those obligations. If not, what does that mean? If there's no contract, what does the law impose in terms of duties and the breach of those duties? So it's quite a broad canvas, as well as the contractual and tortious side. A lot of construction involves insurance angles as well, insuring the building, insuring the individuals who are designing it, insuring the entities who are constructing it. So there's the point I'm attempting to get across is it's in terms of subject area, it's very broad, and it's got attractions for that reason. So I identified that there's the non-contentious side, the bits which I deal with almost exclusively, and I suspect this may be the same for other members of chambers who deal with this type of work, is where things go wrong. So that's where, for example, there's a wide range of different issues which arise on a building site or on a civil engineering project, but generally the disputes centre on money. Has the contractor been paid for the work he's done? Often the contractor or the subcontractor considers they've been told to do work which is additional to what they had in fact agreed to do. So then there's a factual argument as to whether the works have been varied. Has the contractor or the person employing him complied with the requirements of the contract in terms of those varied works? What is the mechanism to value those works? I mean, on the surface, it might sound rather dry, but actually it is quite interesting. And, thinking about it from your perspective as an individual, if you've employed a builder to build I don't know, for example, a conservatory to the front or the side of your house, if you ask him or her to vary the layout or the window levels, you may think that's a fairly routine thing which doesn't involve additional cost. But from the contractor's point of view, it may involve different lintel arrangements, different ways of working, which the contractor considers has incurred it in cost over and above what it agreed to do for you initially. So you can see that even on a fairly routine projects, even in terms of something as maybe nondescript as doing the extension at home, there is scope for dispute. And then you magnify that 10, 20, 30, 40, 50 times in terms of projects, in terms of their physical size and their monetary size, you can see how that there's scope for argument and debate in terms of things which you might consider straightforward, such as payment. So that's but one of the issues which may arise. The other area which I tend to do a lot of work on is in connection with where the employer is involved or has retained an architect or an engineer. These are the people who design the building. And you can see when he or she has designed a building, a complex structure with many different parts interacting with the ground and the environment, there is a scope for something to go wrong. And that's an interesting area because you are getting involved quite heavily in the technical side of it as well. So you need to understand, say, for example, if there's been a dispute as to groundworks, whether foundations which are holding up a building have failed, you need to understand the basics of the soil mechanics, how things were functioning, what the engineer should or should not have done. And in that regard, you're assisted by experts. And if you've got an inquisitive mind, you like science, things like that, it's actually a really challenging and interesting thing to do. So certainly from my perspective, and I'm sure that as you deal with this area, it's very interesting. I mean, I can't even put up a shelf at home, but to be able to sit down with, professionals, architects, engineers, builders, and to understand the intricacies of what they do, it is actually professionally quite fulfilling from my perspective. So that's an area I deal with quite a lot, is professional negligence. Allied to that is the actual defects in terms of workmanship. Has the contractor built the wall in the appropriate manner? Does it comply with you might have heard of this, NHBC guidelines? There's a myriad of different things to look at as well, and then how that interacts between what the professional designed and whether the contractor has constructed it in accordance with the designer's drawings and plans. So in a massive overview, that is the contentious side and the non-contentious side. I'll just say a quick word regarding the various areas in which construction disputes can be resolved, because over the last 20 years or so, there's been a bespoke dispute resolution procedure which has found a lot of favour has been used commonly, which is adjudication, something that I and other members of Chambers are involved in quite often. And Parliament passed some legislation in 1996 which imposed on the construction industry a certain type of dispute resolution procedure called adjudication, and it's a 28-day turnaround procedure. I think it's fairly unique to construction. It might be there in other areas of law, but certainly in my experience, it's heavily used by the construction industry. And that's a 28-day, very quick turnaround, quite intensive work, often as part of a team with solicitors and experts dealing with disputes. So that's at one end of the scale and a very quick procedure. The other, which you'll be more familiar with, is litigation. So that's disputes taken through the court procedure. And there is a specialist court called the Technology and Construction Court, which was set up to deal with these types of disputes, construction, engineering, and technological disputes. The court service recognised there was a need for a specialist court with judges who were experienced in this area to deal with these types of technical disputes. So if you are involved in a construction, engineering, or technology dispute, you are likely, depending on the value, to be conducting it in that specialist court. So you'll see there's a whole structure which has evolved to support and assist the construction industry. So I've talked there about domestic construction. I realise I've counted through it at quite a quick pace. I've spotted some questions have cropped up, so I might just have a quick go looking at those and answering them, and then before I hand over to Johnny to deal with the arbitration and the international side. So one of them, the question is, does construction fall within commercial and chancery? Well, the answer is it depends. There is as I've said, there is a specialist court, the Technology and Construction Court. Construction disputes are a form of commercial litigation. That's all they are, with the specialist courts developed to deal with that. Chancery is more on the trust and property side, but you're right, it's commercial litigation. So the other question which has cropped up is about building a network of professionals, and yes, that's absolutely the case. I think all of us will have our little black book of experts that we would like to use: architects, engineers, quantity surveyors, people who have been through the court process, understand the issues, people that we would recommend our solicitors to instruct to advise us on the liability issues. So from that perspective, it is interesting because you do have a wider network of professionals that you deal with. So the last question, I think, is about, I might hand this over to Matthew at the end. It's a question about pupillage and specialism. So that's not something that I can answer, I'm afraid, about specialising during or after pupillage, but Matthew will no doubt deal with that. So John is now going to pick up and deal with arbitration and the international dimensions which can arise in both construction and arbitration.
Yes, hello, thank you, Simon. I assume everyone can hear me, but no doubt you'll tell me if not. And as I go along, feel free to jot down your questions on the chat or the Q&A, and I will try to answer some of those at the end. As Simon says, I am going to deal with a couple of topics, actually. I'm going to start with arbitration. I'm also going to deal with international disputes and technology law, because those are also aspects of my practice and aspects of practice in this section. Arbitration, there isn't a great deal to say about it, really. I mean, for those of you who don't know, it's basically a private court. So in other words, rather than going to the usual court, then usually because of what's been decided in a contract, parties will have to go to a private dispute resolution venue. The procedure is largely similar to being in court in a commercial dispute. I suppose the advantages are, perhaps disadvantages, depending on your perspective, are the confidentiality of the process and of what goes on and of the result. And also the parties, to some extent, get to choose their arbitrator and have some input into the procedure to be adopted. So it can be more flexible than court practice. It's typically confidential. In terms of arbitration practice for a barrister, it doesn't make a great deal of difference in my experience, whether you're litigating a dispute through the court or taking it to arbitration. You're still going to have witnesses to cross-examine. You still have to make your case and prove it to the same standard. You have to be aware of some of the peculiarities of arbitration procedure, but largely speaking, it doesn't make a great deal of difference, I don't find, to our practice. Simon has dealt with adjudication. That's in many ways similar to arbitration, although for the most part, adjudications are dealt with on paper rather than in a live forum. But the same considerations arise in terms of enforcing the award if it's not complied with by the losing party. So I don't plan on saying any more really about arbitration, but as I say, if anyone has any questions, feel free to jot them down. The next topic I'm going to talk about is international law. They usually ask me to speak about this because I spent 2 years, I think when I was about 6 or 7 years into my tenancy at King's, I then went and spent 2 years in the British Virgin Islands doing some international work there. So that's why I've managed to keep up a bit of that practice, and I'll be talking about that today. The international law that we largely practice in the commercial team is what you would describe as private international law. So it usually involves contractual disputes where the parties are simply in different countries. For my part, I don't deal with international human rights cases or anything along those lines. It's usually just a commercial dispute with an international aspect. It sadly doesn't involve a great deal of international travel, although occasionally you will be asked to go to a court abroad or to meet clients abroad. But it often does mean working with teams of lawyers from other jurisdictions, which is interesting in its own right. The cases themselves are usually of a similar type to the domestic disputes that I get involved in here. Often there's a little bit more at stake, a little bit more money involved, but the issues are usually fairly similar. There can be an extra layer of complexity, as you might imagine, if questions arise over which law governs the transaction or the dispute, or where the dispute should be tried. Sometimes one party will embark on proceedings in one jurisdiction, and the other party will embark on proceedings on the same dispute somewhere else in a different country. So it can get fairly complicated, but it's usually fairly interesting resolving this type of dispute. It often involves enforcing a foreign judgment or a foreign arbitration award in this jurisdiction where similar issues arise. And indeed, sometimes the parties will want to try to secure the assets that they're going after before they even have a judgment on the substance to prevent those assets being dissipated. So it can result in applications for freezing orders and the like in other jurisdictions, quite often in the Virgin Islands. And it also arises in the sports context. So I do a bit of sports law, and sometimes if you have a case that is heading for the Court of Arbitration for Sport in Switzerland or some other sports tribunal, which tend to be in Switzerland, then it often involves working with lawyers from other jurisdictions who have sports experience in a similar vein, and may be part of the overall legal team representing your client in that forum. It's hard to give an example of a typical case in a private international law dispute, but I can certainly give an example, which is one I dealt with a few years back. It concerned a Japanese man, a very wealthy Japanese man, who had moved to Hong Kong and made a large amount of money trading derivatives. The trades were conducted through a company or a series of companies which were incorporated in the British Virgin Islands. And so his fortune largely consisted of shares in those BVI companies. The guy then died, very sadly, in his old age. And his nephew then came out of the woodwork with a clipping of some hair that he said he'd taken from the guy's deathbed, and a DNA test, which he said proved that he wasn't actually a nephew, he was his son. So he wanted the shares. The widow also wanted the shares. And so the question arose, well, before we decide who gets the shares, how do we decide that question? Is it a question of Japanese law on the basis that this was a Japanese national? Was it a question of Hong Kong law on the basis that he died in Hong Kong and that was the place of his residence? Or was it a question of BVI law on the basis that the shares were situate in the Virgin Islands? So that's the type of dispute that may arise in this context. It raises what we call conflict of law questions. For my part, I find that kind of dispute fairly interesting because it tends to involve quite a lot of legal research and quite a lot of thought goes into it. And as I say, it can involve a bit of travel and it involves a bit of working with colleagues from other jurisdictions. I'm also going to talk briefly about technology law, and not least because I've seen there's a couple of questions about that. Technology law, I think the observation has been made, it seems to be rather similar to construction, and certainly it's grouped together with construction in the Technology and Construction Court. And as a matter of substance, it is similar in many respects to construction law, because the disputes often arise out of large projects with issues of mixed responsibilities. You'll have teams of developers, project managers, and the client. The issue is usually who caused the delay to the project, or whose fault is it that the software doesn't do what it's supposed to do. It will often be resolved with the aid of expert evidence, and there's always plenty of scope to argue about who should have done what, when, and how things ought to have happened differently. So in that respect, it can be quite similar to a construction dispute, and I think that's probably the reason that they're lumped together in the same court. It's not the case that everybody who practices construction also practices technology and vice versa. I do a bit of both, although I do quite a bit more construction, I would say, at the moment. By way of example of an IT case, there's a reported case from a couple of years ago. It's actually a Singapore case about algo trading and cryptocurrencies. It concerned a crypto trading platform where someone was using software to trade cryptocurrencies. The software carried out some trades, and because of the combination of issues with the platform and the software, it managed to acquire some Bitcoin at about 250 times less than the going rate. And the platform then reversed the trades, saying that there was a mistake which affected the contracts. And unsurprisingly, the person who had acquired the Bitcoin was rather disappointed about that and brought proceedings to get their Bitcoin back, essentially. So there were quite a few questions which touched on the law of mistake, the law of contract, whether contracts can be made by software agents, and indeed whether Bitcoin and other cryptocurrencies represent property for the law of property. So there are some interesting issues which arise, perhaps ever more so these days. And yeah, for me at least, it's another interesting area. It's probably fair to say that a lot of this work doesn't have as much of the human interest element that you might have in some other areas, such as family law or crime. But I think there's a lot of scope for making technical legal arguments in sometimes untested areas. And if you're interested in business and economics and getting an insight into a pretty diverse range of industries and markets, then it can be a very rewarding area. So I'll just have a look at some of the questions. I've got, does international law include admiralty and shipping? No, not really. We don't. I don't think we do a great deal of shipping and that kind of thing in chambers. I guess that there will be shipping cases with international aspects, but we don't have a shipping team. Sport, and is it common to diversify between disciplines? I think certainly within the commercial and chancery team, or the business and property team, I should say, there are a lot of practitioners who do have a fairly diverse collection of areas. So yes, I think it is fair to say that there is some diversity. Can you please send the name of the case on the crypto trading? It was called B2C2 and Quoine, from memory, B2C2. And if you were to be a solicitor in this area of law rather than a barrister, what would the area of law be called? I think it would generally fall under business and property or commercial litigation, something along those lines. And in terms of what to study at uni, the core subjects, I guess, for us are contract law, tort, and if we're really talking about specialisms, I guess construction law, insurance, and things of that nature. I think that's pretty much time up. So I will hand over to, I think, Richard and Louise. Thank you very much.